In this video, we will conclude this week's module by considering the measure of damages available to the buyer upon its rightful and effective rejection of the seller's non-conforming tender of goods. Where the buyer rightfully rejects the seller's non-conforming tender, then from the buyer's perspective, it's as if the seller had never delivered the goods at all. Indeed, as we noted at the beginning of this module, the same provision that outlines the buyer's remedies where the seller fails to tender the goods, that is section 711 subsection 1, also applies where the buyer rightfully rejects the goods. Specifically, that section governs both the buyer's rights where the seller fails to make delivery of the goods and also where the buyer rightfully rejects the seller's non-conforming tender of goods. In each of these scenarios, the buyer's remedies are essentially the same. The buyer has the right to cancel the contract. That means the buyer need not make any further payments that would otherwise be due to the seller for the rejected goods. Stated differently, the seller does not get paid for the rejected goods. And in addition to cancellation, if the buyer has already paid the seller for the rejected goods in full or in part, then the buyer is entitled to recover the amounts it's already paid to the seller. Note here, however, that unlike a buyer who suffers a breach because the seller failed to tender, so the buyer never got her hands on the goods, where the buyer has rejected the seller's non-conforming tender of goods, then the buyer is in a more enviable position. That's because of subsection 3 of 711. That subsection says that where the buyer has rejected the seller's non-conforming tender of goods, and the buyer has the rejected goods in her possession, then the buyer has a security interest in those goods. Security interests are governed by Article 9 of the UCC, so they are obviously beyond the scope of this course. But for our purposes, you can think of a security interest as essentially a lien on the rejected goods. It means that the rejected goods are now collateral in the buyer's possession, securing the seller's obligation owed to the buyer. Specifically, until the seller repays the buyer any amounts the buyer has already paid for the rejected goods, and any expenses the buyer has reasonably incurred in the inspection, storage, and care of such goods, the buyer may possess the seller's rejected goods and may even, after waiting a reasonable period of time, resell the goods to recover these costs and expenses. The rejecting buyer can do these things, including resell the goods, even though such actions would be inconsistent with the seller's continued ownership of the goods. In this context, the buyer's exercise of its rights under 711 subsection 3 would not constitute an acceptance by the buyer. So in short, the buyer is entitled to recover any amounts that she has already paid the seller for the rejected goods, and then coming back to subsection 1 of 711, in addition to any such amounts, the buyer is entitled to seek damages against the seller for the seller's breach. And here again, the measure of the buyer's damages are identical to what is available if the seller had simply failed to tender the goods. The buyer may either seek Section 712 cover damages or Section 713 market damages, plus, of course, damages for any incidental and consequential losses recoverable under each of these sections. So the buyer's measure of damages, where the buyer rejects the seller's non-conforming tender, should be a familiar one. Upon the buyer's rejection, the buyer may cover and seek damages against the seller equal to the difference between the cost of the buyer's cover for substitute goods minus the cost of the goods under the breach contract, the cost the buyer expected to pay the breaching seller, plus damages for buyer's incidental and consequential losses. Or, where the buyer doesn't cover pursuant to Section 712, the buyer may instead seek market-based damages equal to the market price of substitute goods, that is the price the buyer would have paid had the buyer chose to cover, minus the cost of the goods under the breached contract, the price the buyer expected to pay for those goods to the breaching seller, plus again the buyer's incidental and consequential losses. So let's finish this module by reviewing what we have learned so far and previewing where we will be headed in the next week. Where the seller makes a non-conforming tender of goods, the buyer has a binary choice to make. The buyer may either reject or accept the seller's tender. As we saw this week, the buyer's right to reject the seller's tender is defined by the perfect tender rule and its exceptions. But even if the buyer has the right to reject the seller's tender, the buyer must exercise that right effectively. That is, the buyer must make an effective rejection. Where the buyer makes a rightful and effective rejection of the tender, then we saw that in some cases, the seller may have the right to cure the nonconformity that led to the buyer's initial rejection. Where the seller does not have the right to cure, the buyer may exercise the remedies described in 711. Those remedies include canceling the contract and collecting cover damages under 712 or market-based damages under 713, plus incidental and consequential damages as those are defined under 715. Note the same would be true even if the seller has the legal right to effect a cure but fails to do so. But where the seller does exercise that right, that is, cure its breach, then the buyer can no longer reject. The buyer must accept the seller's cure. though that does not change the fact that the seller did initially breach. The difference is that the buyer must pay the seller the contract price for the tendered goods and seek damages against the seller for the seller's initial breach. As we will see in next week's module, the buyer's measure of damages in this scenario is the same measure of damages where the buyer accepts the goods, and it is a different measure of damages than the ones that we have seen up to this point. But we can save all of that for next week. For now, that concludes this week's module, in which we examine the buyer's rights, obligations, and remedies where the buyer rejects the seller's non-conforming tender of goods.